Welcome to Altea Talks, the brand new podcast series being brought to you by Altea, the unique provider of combined insurance and risk management solutions designed exclusively for the medical, allied health and care sectors. I'm going to be your host, Will Marshall, and I'll be joined in this series by some of the leading movers and shakers from across the sectors. My guests are going to include practitioners and professionals, regulators, clinical risk and governance specialists, and an array of legal experts who are going to help us get to the heart of the hottest topics affecting the UK's health and social care sectors today. So, if you're looking for frontline knowledge and expertise, if you want valued insights into these most dynamic, challenging and rewarding of sectors, then look no further because you're in the right place. Welcome again to Altea Talks. Hello and welcome to this latest episode of Altea Talks. I'm delighted today to be joined by Tracy Sell-Peters. Tracy is recognised as one of the country's leading healthcare litigation lawyers at Keystone Law, where she manages a team of highly talented lawyers working across the full spectrum of healthcare litigation. Tracy's own practice encompasses claims, regulatory cases, advisory, criminal and inquest work. Tracy's claims experience includes advising on a range of high-value and complex clinical negligence claims. She works across many disciplines, including orthopedics, plastic surgery, ophthalmology, neurology, and neurosurgery, handling claims against surgeons working in the NHS and in the independent sector. Today, we're going to be focusing predominantly on Tracy's regulatory expertise. Tracy is a nationally recognised leader in this field. Tracy and her team defend numerous doctors, dentists and other healthcare professionals whose registration is called into question by the GMC and the other healthcare regulatory bodies, including the General Dental Council, the Nursing and Midwifery Council, the General Optical Council and the Health and Care Professions Council. Tracy also represents practitioners and entities in independent inquiries, complex inquests, NHS disciplinary proceedings, and private hospital investigations, working with a range of providers and their insurers. Tracy, a very warm welcome to Altea Talks.
Thank you very much for those very kind words, Will. It's lovely to be here.
In this episode, we're going to be focusing on matters regulatory. In particular, we're going to be looking at the good medical practice standards that were revised by the General Medical Council in January of this year. And we're going to be looking as well at the Health and Care Professions Council's new revised standards of conduct, performance and ethics that are valid from the 1st of September this year. And then we'll be looking more widely at some of the key themes, trends, issues that Tracy and her team are seeing in regulatory cases at the moment, and having a look at some of the risk factors and steps that practitioners can take to reduce their risks when they're faced with regulatory proceedings. So to start at the top, we'll start with the good medical practice. And I think, Tracy, it'd be really helpful if you could give us an overview introduction to GMP and really talk a little bit about the evolution of healthcare regulation.
Of course. Well, it's very interesting to think about how far into the evolution of healthcare regulation we are, much further than most people would recognise and acknowledge. The GMC was actually founded in 1858, obviously well before the NHS. At the time the Medical Act came into force in 1858, there were 19 bodies regulating doctors. And at that stage, obviously, many doctors didn't have any proper, as we would consider them now, professional qualifications. So we've gradually been evolving from a position of self-regulation to one of now professional regulation. And certainly when I started in practice 25 years ago, we were still looking in large part at self-regulation. The position has very much changed. So the Medical Act covers 5 principal areas, and these are the areas which there's a statutory responsibility on the General Medical Council to police these areas, and those are managing the medical register. So that's making sure that every doctor in this country has the requisite knowledge, skills, qualifications, and experience to work in the UK. Setting standards for doctors, and that's where good medical practice comes into play. Ensuring standards in education and training. Revalidation, which is a fairly recent concept starting in 2012, and investigating and acting on concerns, which is what most people will know about the GMC. Those are the cases heard by the Medical Practitioners Tribunal Service, the so-called fitness to practice cases. So we started in a position in 1995 when we had the first edition of Good Medical Practice. And this was the first positive statement about the standards of care patients should expect and doctors should work towards. In 2012, we had revalidation and the oversight that's now paid to doctors keeping their knowledge and skills up to date. In 2013, we had the last version of Good Medical Practice, which has now been superseded by the 2024 Good Medical Practice. So for people like me, the 2013 guidance has been what we've been working to for a very long time. But the 2024 Good Medical Practice shows us what an evolving landscape this is, and we'll talk about that in a moment. I would like to say a little bit about what the GMC did to come up with and arrive at a position where they could embody this new version of Good Medical Practice, because they really did undertake a very holistic assessment to learn from the public at large, from healthcare professionals and others, what is expected of medical professionals. So there was a big exercise, and it took learnings from large-scale inquiries as well. We'll have all heard about those, Mid-Staffordshire. There are many.
They spoke with specific groups.
They did. They spoke to 4,600 individuals. So they did two things. They did surveys, and they also met in person. But as you say, they spoke to specific bodies, groups of people who I think it was probably considered were underrepresented. So minorities, people with different religious beliefs, people for whom English isn't their first language, asylum seekers, Roma and Irish travellers, LGBTQ plus and transgender people, people with disabilities, mental incapacity, homeless people, domestic abuse survivors, parents and pregnant women, carers, and ex-offenders, interestingly. And in that research, they looked at exploring 8 key aspects of good medical practice, which we're going to touch on in a minute.
That's fascinating. Thank you. Just looking at good medical practice, can you just explain a little bit about how it is intended to align with modern healthcare practices?
I mean, good medical practice obviously has to evolve with public expectations of modern healthcare practices, and it sets out to establish principles and values and the standards of care and professional behaviour that we expect of medical professionals. And it's an ethical framework which is designed to support medical professionals to deliver safe care in the interests of patients. So it sets out standards of patient care and behaviour which are expected of all doctors across the UK, and it's also going to apply to physician associates and anaesthesia associates in the future once they come into GMC regulation. So it isn't a set of rules, but it is designed to both shape and reflect modern healthcare practices. And it effectively requires medical professionals to use their professional judgment to apply the standards in their day-to-day practice. And that means working out which of the standards are relevant to their circumstances with that particular patient and using their knowledge, skills, and experience to follow that through. So although it isn't a set of rules, it does have terms like you must and you should. And obviously, you must is used for a legal or ethical duty that a doctor is expected to meet. And you should is used for duties or principles that either may or may not apply in that situation, or you might not be able to comply with because of factors outside of your control. So that's the basis of how it is designed to operate.
That's interesting. What is the legal status of must duties, and how are breaches of must duties used against doctors by regulators in fitness to practice proceedings?
Yes. I mean, it's an interesting point because, as I've said already, this isn't the law, so to speak, but this is guidance from the regulator. And what happens in practice in a fitness to practice hearing, which is where a doctor is facing allegations, is that if it's a clinical case, the General Medical Council will generally instruct an expert, the doctor will instruct an expert, and the debate in front of the tribunal will be about whether or not essentially that doctor behaved reasonably. And in considering the you must good medical practice guidelines, that would essentially be a question of whether or not the doctor had done what that particular expert considered to be compulsory in those circumstances based on their own experience and their own interpretation of good medical practice. And if they didn't, it would probably be found that they had breached the standards expected, and that was seriously below the standard expected of that doctor.
Thank you. And we heard that the new standards, the new good medical practice, was introduced in January of this year. Could you tell us a little bit about some of the key changes that were brought about by the new GMP?
Yeah, I will. I mean, there are quite a lot of them. So essentially, the new GMP covers 11 categories in 4 domains. And I'm going to highlight a number of those domains now where there are the most significant differences, if that makes sense.
Thank you.
So the first domain in good medical practice in 2013 was around knowledge, skills, and performance. That's now called knowledge, skills, and development. And in the preamble to that section, the GMC highlights that medical practice is a lifelong journey, keeping pace with rapidly changing social, legal, and technological developments means learning new skills while maintaining others. So this is an interesting area for me in terms of the work I do in this space, because this expands competence into work involved in doctors in their leadership roles, reflecting a greater focus on leadership. And the changes could potentially broaden for the opportunity of the GMC to take witness practice action against board members, in addition to any actions the CQC might take. There's a much greater focus on development, both in the personal sense and also in terms of wider improvements in healthcare. There's a new provision that doctors should reflect on the risk of unconscious bias by considering how their own life experience, culture, and beliefs may impact on their decision-making. There's an expectation that doctors will contribute to discussions and decisions about improving the quality of services. And these will all likely be discussion points for annual appraisals and revalidation. There are specific provisions about remote consultations as well.
Thank you. And what are some of the core principles of the new GMP?
Well, I mean, the ones we haven't touched on, the other areas are safety and quality. So there's a core principle about patients, partnership, and communication. There's another one around colleagues, culture, and safety. There was very little about culture in the 2013 guidance, so that's a very new area. And there's another big domain around maintaining trust and professionalism. And as we all know, cases of dishonesty against doctors continue to be heard by the regulator and continue to be a problem for people like me. So the core principles, I would say, are patient-centered care. So caring for the whole patient, which is obviously in keeping with all of the case law around Montgomery in the civil space. So that now is said by the GMC to include things like appreciating the psychological factors that patient is subject to and the overlap between their physical and mental health, appreciating cultural and religious beliefs which can influence their decisions regarding medication, treatment, etc., tailoring the doctor's approach to the patient's literacy level and their mental capacity, understanding their social relationships, such as are there signs of domestic abuse or isolation and loneliness? I mean, really requiring a doctor to have a very holistic approach to an assessment. Have they encountered any major life events? Do they have any protected characteristics? Is there anything about their appearance and behavior that shows, for example, signs of self-neglect or abuse? So all of those issues around patient-centered care. Another theme that's been highlighted is around communication. You know, that's a perennial problem, isn't it? Often patients take umbrage because they don't like the way that doctors communicate with them. So that was a theme that emerged across all the groups that we touched on earlier in our discussion. The need for better communication, the need for doctors actively to actually listen to the patient, to consider their views, and to ensure that the patient feels heard and satisfied. To be transparent with patients about waiting times, delays that might ensue, all of those sorts of things that doctors really skirt over normally. And the responsibility on doctors to check that patients understand the information they've been given and to do their best to give patients the time they need to make informed decisions. So those are 2 core principles. And the other one I would focus on is continuity of care. That's been shown as a real area where problems have arisen in the past. So there's now heightened expectations on doctors to share information with other medical professionals about that patient, name a clinician or team who's going to take over responsibility for that patient when their role in that patient's care has ended. We do a lot of cases where patients essentially fall between the cracks.
Yeah, and it's very interesting, the comment that you made about the extent to which the revised standards reflect the law and recent or relatively recent changes in the law around things such as decision-making and consent. Is it your view as well that the reason why culture is such an important component of the revised standards reflects some of the concerns that have been raised in recent years by the various patient safety scandals that we've seen, for example, in maternity care or with the Countess of Chester Hospital and so forth?
Absolutely. I mean, I think it reflects what we've seen from the patient bodies, but also from within the profession itself. I mean, a lot of what I see in terms of poor culture is actually internally poor culture at trusts, in private hospitals, between colleagues. So I think these guidelines are shaped both by the public temperature at the moment, but also by what's gone wrong recently. And it's a direct response to the fact that we must tackle discrimination. Doctors have to show respect and sensitivity towards others' life experiences. All of these things reflect the dynamics we're seeing in society generally, don't they?
Yeah, I think that's right. And that goes back to the breadth and extent of the consultation carried out by the GMC, and the various groups that you helpfully explained had been consulted in making these changes. Can I just ask, as a regulatory lawyer, what impacts from the new GMP are you seeing, well, good and bad really, in your regulatory practice?
I do a lot of talking to doctors, and I'm seeing a lot of negative reaction, to be perfectly honest, a sort of reaction around, well, how are we possibly expected to do all of this as well as everything else we're already having to do? So I think there's a problem there, and I was going to touch on that a little bit more because I think this is going to give rise to more complaints about doctors. I really worry that they're not going to be able to satisfy all of these expectations, honourable and admirable as they are. So yeah, I think I've not seen yet, because obviously these cases take a long time to come to fruition. I haven't seen any specific allegations yet that reflect these things, although I have had a lot more cases in the sort of discrimination space recently. I've had some in the transgender space. So I think we are seeing it, and we're seeing heightened patient sensitivity, and we just have to accept that that's the real world that these doctors are practicing in.
Mm. It'll be interesting to see how that pans out going forwards. Can we just move on, Tracy, to look at the HCPC standards, with the Health and Care Professions Council also issuing revised standards of conduct, performance and ethics. But before we go on to that, are you able to start by explaining a little more about the sectors that HCPC regulates and works with?
Well, the HCPC is a mammoth regulator. I mean, it regulates 15 allied health professional groups, including paramedics, physiotherapists, speech and language therapists, but things as diverse as drama therapists, occupational therapists. It's a difficult task for the HCPC because unlike the GMC, there's so much variety amongst the professionals it does regulate. So I think it's a tall order for them to come up with these standards, but they have come up with standards. As you say, they come into effect in September, and they're very similar to the GMC good medical practice standards, in my view. They're around promoting public health and preventing ill health. Things like we've just been talking about, understanding the social, economic, and environmental factors influencing a person's health, encouraging them to manage their own health. Equality, diversity, and inclusion, that's the second area. Responding to the needs of all different patient groups, service user groups, they like to call them in the HCPC. Respecting and recognizing the impact of people's personal values, beliefs, and biases. Identifying when a user's care needs to be adjusted, and proactively thinking about how to make their care more accessible. So that all comes under the equality, diversity, and inclusion piece. Centralizing service users' experience. So again, that comes into the sort of continuity of care space. It also touches on confidentiality, recognizing the service user's role in decision-making. There's a specific piece on mental health, understanding that, adopting clear strategies to help people with self-care and self-awareness. Previously, standards at the HCPC didn't mention mental health of registrants at all. There's a piece around digital skills and new technologies that extends to things like clinical records. As I say, that's a different piece. All of this is difficult because these professions are all so diverse. And again, there's a leadership piece. So it's quite similar, really, I think.
What's the legal status of the HCP standards? Is that similar to GMP?
Yeah.
And again, is compliance with the standards something that you see regularly referenced in the disciplinary cases that you're handling for that, for individuals appearing before that regulator?
Yeah, it is. And it's interesting at the HCPC because I've done a number of cases recently where they will refer cases to hearings before even taking any expert evidence. So, that's a difficult thing for a registrant to face, is potentially having their own supportive expert evidence, but still finding themselves at a hearing, which may not result in a hearing once the regulator gets expert evidence. But yes, it's a similar kind of dynamic.
And these sorts of proceedings are always very tough on the practitioner, aren't they?
Unbelievably tough. And suicide of registrants in this space is not an unheard of thing. I think it's even more common with HCPC registrants. It's something I'm acutely aware of. Anytime I'm advising anybody, you'd have to be pretty robust not to be undermined or actually destroyed by some of these investigations.
So just widening it out a bit there, Tracy, thank you for commenting on the GMP and HCPC standards. But if we could just speak a little bit about some of the wider important themes that you and your team are finding from your work on regulatory cases at the moment.
Yes. I mean, it's hard to come up with a short list because we see an awful lot of different things happening, sometimes quite surprisingly. But one of the things we see, which I think is particularly interesting for those who may be listening to this podcast, is around complacency and the need for early engagement and indeed notification when you're dealing with your regulator. I mean, it's quite incredible the number of practitioners who we speak to who will say, yes, these concerns have been raised, but obviously there's nothing in it. I mean, I wouldn't possibly have done this thing. I've just put in a statement. It's all going to go away. And for us as lawyers, that's just the worst thing that could possibly happen, because I'm afraid that statements drafted by medical professionals, unfortunately, generally don't get the balance right in terms of demonstrating the level of reflection that will be expected by the regulator in these circumstances. So my advice on that is, no matter what your personal view is of the merits of a particular complaint or a particular hospital investigation or whatever it might be, engage somebody who really does understand this space at an early stage so you can get some proper advice. I mean, we've seen hospital investigations happening so much more readily these days. When a patient complains to a hospital, a private hospital, NHS hospital, they feel obliged to investigate them. And you need to take these things seriously. They may not amount to anything, but you need to go through and follow through with the process. I mean, I always talk about dishonesty. I'm afraid we still see dishonesty quite regularly. The GMC have very strict rules now around dishonesty. The test for us as defendants within dishonesty cases is very strict. It's not appropriate not to be entirely candid and honest when something goes wrong. That doesn't mean you go around admitting liability to everyone before speaking to your insurers, of course, and taking some professional advice. It does mean that, if, for example, you have been dishonest about something, it's time to fess up, because doing so will mean absolutely that you'll get a better outcome, and not doing so will put you in a much worse position. One of the other dynamics we see a lot of is poor team working. Vendettas, rivalry, greed, lack of respect, just general toxic team dynamics in the NHS, in the private space, competition for income, competition for patients, resulting in disciplinary investigations and sometimes referrals to the regulator. Honestly, sometimes when I get the papers in on a new case, I can't believe how medical professionals have behaved to each other. Just, really appalling, nasty. One of the themes of good medical practice, the new version, is kindness and compassion. That's not just talking about patients. That's talking about everyone we engage with. So that's a real issue. I noticed in the BMA conference last year, they had a big piece on the corrosive culture of bullying that still exists within the NHS. We really need to do something about it. I know women feel particularly strongly about that, but as do other ethnic minority groups and others. Generalized lack of empathy amongst colleagues. I often see it that when something goes wrong for a medical professional, nobody wants to know about it. A senior consultant who's done nothing but support patients and colleagues their whole lives, everyone turns the other cheek. I've also seen a lot more in recent years of patients making, frankly, unsubstantiated allegations against medical professionals, some of them of a serious nature, including a sexual nature. And I always recommend seriously considering chaperoning, not just in intimate examinations, but others, and taking very careful consent from patients. Because if you're in a room with a patient who makes an allegation and there's nobody else in the room with you, it's one person's word against the others. I know that the GMC is, there is chaperoning guidance. Everyone should be very aware of it, but it's something that should be considered carefully. I've also seen a lot more instances of nursing staff making claims against doctors more regularly. I think that reflects a general disquiet amongst teams about all those power dynamics, perhaps people not treating each other very well. And what happens is when things go wrong, people are much more willing to make a complaint. That again highlights this need for better communication. So the other thing I like to touch on is doctors breaching professional boundaries in the social media space. That's something we see an awful lot. Doctors WhatsApping patients, communicating with them on other social media forums, which in my view are to be avoided because they lead to a real blurring of boundaries. Sometimes,
yes.
Not always.
No, that is interesting. And of course, we've touched on that in a previous podcast as well. And to what extent do you think it's very interested to hear what you were saying about the toxic teams cultures that you're experiencing. To what extent do you think those sorts of issues have been not encouraged, but brought to attention by the various cases that we've seen over the last year that have highlighted the importance of speaking up, the importance of whistleblowing in the sector?
Yeah, very much so. But the problem is, I think there's insufficient protection for people who do that. And, that's a very difficult place to find yourself in, where you've effectively done the right thing. You've been the whistleblower, and then you've got to go through potentially retaliatory complaints. It's not as straightforward as it should be for someone to whistleblow and then be protected effectively.
Yeah, thank you. You've touched in your answers on some of the risk management strategies that medical professionals or healthcare professionals can take in looking to protect themselves from regulatory referrals. What other tips would you have for practitioners or for insurers of practitioners to help to reduce the risk of regulatory referral, or in the event that a referral has been made, to secure an early resolution of that before it proceeds to the full-blown fitness to practice hearing?
Well, the one thing in terms of reducing the risk of referral, that's a huge topic, but certainly good communication is going to help you, because I do find it's often the case that the communication between the doctor and the patient has just deteriorated for one reason or another, often because the doctor has not been particularly sensitive to what the patient has to say and has been dismissive. So, one needs to be aware that you're dealing with a person who feels aggrieved. And the way not to do that is to just be dismissive and defensive. So that's a good way to avoid being in that space. But if you do end up in that space, yes. If you have a helpline with your insurance that you can phone, please do that immediately. There's no downside to doing so. In fact, it's absolutely the right thing to do and will help you in the long run. Please show insight and reflection. I always say to people, take a pause, take a deep breath, and then respond. And if you can get some legal advice before you respond, even better. Don't try to cover up mistakes. They are expected. It's how you deal with them that makes the difference. Don't fire off lots of defensive knee-jerk emails that will present someone like me with an evidence trail that I've got to then try to explain at the same time as saying, oh, this doctor's a reformed individual and they've got so much insight. Well, that puts us in a very difficult position. Don't alter the records. We still see people falsifying medical records. Don't try and get patients to change their accounts or withdraw their complaints. I've got a case going to a hearing probably next year where somebody had hired a PR consultant who effectively tried to convince the patient not to refer the doctor to the GMC. That's now in the allegations. Speak to colleagues and line managers. Get as much support as you can, because it's a very lonely place when you've had a complaint, a claim made against you.
Yeah, thank you. Thank you. It's interesting what you're saying about taking early advice if there is an opportunity to do that. And of course, most insurers these days, including Altair, would offer a medico-legal helpline. And certainly we would be strongly recommending to our insureds that they should be seeking advice before responding. And I think the other point that you made earlier about some of the risks around the more informal methods of communication is interesting, because I think that one of the things certainly I recall from when I was in practice is when people are communicating through WhatsApp or a less formal means of communication, there is a pressure to respond or to think that you need to respond quickly. And I think that is of itself risky in a legal sense in any event.
It is. I mean, responding to a patient at 2:00 in the morning.
Not a good idea.
It's not appropriate unless they're in some sort of acute clinical state. Not a good idea. Responding with emojis. Not a good idea. But there's an expectation in those forums that's part of the dialogue, isn't it?
Yes, it is.
Kisses and emojis.
Yeah.
Very hard to explain that away to a regulator.
And they can be screenshot.
Yeah, and increasingly we have to disclose them, because don't forget, not only, I had a client recently, I knew there was lots of inappropriate correspondence, WhatsApp, and he said, oh, I've deleted them all, so I couldn't see them. But of course the patient's got them. So deleting them isn't going to help you either. Don't do it. Email patients or get your PA to email them, but maintain a level of professionalism that is expected. One good tip, and lawyers are told it as well, is if you write something down, are you going to be happy with that being read out in court? Are you going to be happy with that being read out at an MPTS hearing? I had one recently where the doctor said, I'm just getting in the shower and I'll give you a ring. How is that relevant? I said to him, where does I'm getting in the shower have anything to do with a patient? And he was claiming not to have had a relationship with her.
Yeah, well, that's not easy, is it? Well, it's very, very interesting to talk about some of your war stories, Tracy, and I'm sure there's many more where those came from. But I think just to wind up, it would be very helpful if I could ask you to do a bit of crystal ball gazing and just let us know where you're seeing the new trends or the next big issues in the regulatory world.
Well, I think it's quite tidy, really, because I think a lot of them are actually in the space highlighted by the new guidance. Social media use, there's this case involving a GP called Adrian Harrop, who received a month-long suspension from the MPTS for effectively expressing his personal views in the transgender space, which were considered highly offensive by a tribunal. And I've just had a case where their views about the Israel-Gaza situation, we are getting into territory where doctors, other medical professionals have to be very careful about their conduct in their private lives, because that will and could attract scrutiny. It happens a lot in the HCPC and always has, but I think that's starting to be a bigger problem in the GMC and the MPTS. I think we are, as I touched on earlier, going to see more patient complaints coming from these new guidelines. I don't know how doctors protect themselves from them, except in the obvious ways, but they're under a lot of pressure already. The health service is very strained at the moment. I think we'll continue to see problems from the outsourcing healthcare space, that's tricky sometimes. And I think we also have to have a particularly heightened understanding of neurodiversity, both in terms of how it affects patients and how it affects doctors, and how we deal with colleagues who are neurodiverse, and how the regulator, how others appreciate and support that.
That's interesting about the neurodiversity. I think I saw some publicity from the GMC about that in the last week or so, wasn't it?
There is some, and we've been writing on it recently because it really is an area that I think is not sufficiently understood, and it's much more common, and it feeds into the whole thing about supporting, being kind and compassionate.
Yeah, absolutely. Well, Tracy, we could continue talking about these issues, I'm sure, for some time, but I think we'll draw a line under it there. It just remains for me to thank you for appearing on the podcast and thank you for sharing your valuable insights into such an important area.
It's been a pleasure. Thank you very much, Will.
Thank you for tuning in. I hope you enjoyed today's episode of Altair Talks. If you did, please don't forget to subscribe or leave a like or a review on whatever platform you're listening on, as this helps spread the word. If you have any questions or comments or topics you'd like us to explore in future episodes, please do contact us, as we'd love to hear from you. You can find us on LinkedIn or visit our website at www.altairinsurance.com. Stay tuned for more episodes, and until next time, take care of yourselves. The information contained in this podcast is not intended to represent a complete analysis of the topics presented, and it is provided for information purposes only for practitioners in the UK. It is not intended as legal advice, and no responsibility can be accepted by Altair Insurance or Keystone Law for any reliance placed upon it. Independent legal advice should always be obtained before applying any information to particular circumstances.